We'll call the case of Michael Rodriguez versus Chelsea Rodriguez. This matter is before the court on the plaintiff father's motion for to show cause, as well as his objection to a referee recommended order. This hearing is being conducted via Zoom. Are you Michael Rodriguez?
Yes, Your Honor.
Okay. Is Chelsea Rodriguez present on audio? Appears that she is not present. This matter was scheduled for 8:30. It's now 9:20. Mr. Rodriguez, have you texted Chelsea to remind her she's got to be in court this morning?
I text Chelsea and she doesn't respond to me. I've been texting her for a couple of days now.
Okay. The question is, did you text her this morning to let her know we're waiting for
her? No, I didn't know that was my job, Your
Honor.
Do
that. Please do that. And maybe she forgot. Just give her a text. Let her know the court's waiting for her.
I get it. People should be on top of things, though.
Good morning, Ms. Andrus.
Good morning, Your Honor. I don't know if you can see in your file, but it looks like he provided proof of service for today and that we have on file as well.
Yes, there does appear to be a proof of service. Mr. Rodriguez apparently mailed motion.
Should I still text her?
Yes, please text her, Mr. Rodriguez.
Okay.
Okay. With respect to the objections to the referee recommended order, that was mailed by the front of the court office. Is that correct, Ms. Andrus? Well, no, that was the actual recommended order.
All right, I sent her a text, Your Honor.
Okay, let me know when she responds.
If she responds, yes.
Yes, there does appears that Mr. Rodriguez mailed it to Ms. Rodriguez. His objection is a motion for her to show cause, as well as his objections to the referee recommended order. Okay, Mr. Rodriguez, we can at least talk about this matter while we're waiting for Chelsea.
I didn't receive a text yet, Your Honor.
And you didn't receive a response? Is that what your statement was?
Yes, that's what I just said.
Okay, you texted her, but no response, correct?
No response yet, yes.
Right. The Ms. Andrus from the front of the court provided the court fine recommendation. Mr. Rodriguez, obviously your show cause where you're alleging that mom changed schools without your consent, and she changed the names of the children without your consent. The referee recommended order appeared to address that. The referee recommended order was that the children remain in Madera public schools. That's what you're asking, correct?
Yes, sir.
Okay, but you objected to that referee recommended order because it recommended that custody and parenting time continue as previously ordered. You understand that?
Yes.
So if you want to modify custody, or if you want to modify parenting time, you should file a motion to modify parenting time. Right now, your parenting time is...
Isn't that what I just did last time, and they kept it the same, though?
Okay. Well, maybe the court's not satisfied that there's a basis to change parenting time.
I just don't know how. I filed so much stuff. I mean, I know you guys have all the files of everything I've shown you, text messages, and they're constantly left alone, Your Honor. I just don't know what else to do. I'm reaching out to CPS. I'm reaching out to you guys. My kids are not in their best interest being with Mr. Rodriguez. She's always leaving them alone. And my daughter stresses to me on a daily. They are left alone from in the morning time till they have to go to school, from 4:30 till 9. Anyone could break in. I mean, regardless, I'm sure you have children. I'm sure the people in there have children. You would do everything you can for your children, try to make sure they're safe. And my kids are not. They're constantly left alone after school, before school.
Okay.
Hours
so Mr. Rodriguez, you need proof. We said they're alone. I mean, there's no adults in the home.
Your Honor, I have messages I've sent into the courts. I don't know. Are you guys not seeing them? I'm just confused. I could resend them in if that's fine. I could resend my text messages with Miss Rodriguez or my daughter. I mean, they're constantly left alone. I can have my kids testify.
Mr. Rodriguez, file a complaint with protective services. If they're being left alone and neglected,
sir, I did. I had 2 cases open with CPS. They are not doing anything. You guys are not helping me at all either. I'm doing the best I can. Literally, my kids, I do not want anything to happen to my kids. At this point, my kids are left alone so much. Someone's gonna break in, God forbid, or kidnap them. They're not gonna know what to do. They're young, Your Honor. I don't know what else has to go on for me to freaking something to happen to my children. Like, they are left alone all the time. I'm
Okay,
not.
hold on,
I'm
Mr.
stressing
Rodriguez.
out.
Settle
over
down, Mr. Rodriguez.
Like, this is
settle
crazy.
down. Okay,
Like,
we
everyone's
said left
bypassing this, though, Your Honor. I'm a stressed out dad, as you would be at this time. Like, I need help, Your Honor. CPS is not doing anything for me. Miss Rodriguez is going against court order, and nothing is being done. Like, what? I don't know what else to do, Your Honor. I'm doing the best I can. I was doing everything for my children. They're with me 95% of the time because she wasn't here. I'm sorry, I'm stressed out. I'm not trying to get worked up, but this has been a long time coming. I'm not filing the stuff for no reason. I would never try to take anyone from their mother or whatever. They could be with their mom, but they need a stable place to be living. Like, they're in a whole new area where they don't even know where they're at. They're in Canton. They were in Monroe, where they were familiar, and their grandfather lived 2 feet away. Now they have no one out there, and they're constantly left alone. I'm not trying to cut you off at all, but I need someone to hear me. Like, she's doing everything. She's doing everything behind my back. She doesn't answer me. Like,
let me know when you're done, Mr. Rodriguez.
I'm done.
Okay. So protective services must determine that there's not proof that children are being left alone. Otherwise, they would take
there's
action.
proof. Chelsea even said it herself. You can go to CPS and get the files yourself, Your Honor. She even said herself that she leaves them alone. She has left them alone. There's nothing I have to even lie about. There's definitely proof, and I need someone to do something about this. You're the judge here, right? You have the biggest authority of all this. You can see everything truly right in front of you. Miss Rodriguez doesn't even show up for court and still has her favor. I'm just so confused by the court system. Like, I know it's a mothering state, but I'm a father doing everything for these children. Like, I'm really not trying to be all hot-headed, but Your Honor, you have to see what I'm saying. And all the proof I have in there with you guys. Like, come on, man. Like, I'm doing the best I can. I'm so stressed out. My life is a stress ball because of this woman. I have to worry about if my kids are safe or not, like, or even getting to school or at that. Like, I hope you hear my concern. I'm not just venting to vent or to get anyone in trouble. I'm not lying about nothing I'm saying. I've been doing everything I can, Your Honor.
Mr. Rodriguez, can I ask a few questions, please?
Yeah, absolutely.
Okay. Are the children back in Monroe Public Schools now?
No. I don't know where my children live. I don't know where they go to school, Your Honor.
Hold on, Mr. Rodriguez, did you call? Hold on. Can you, did you call the school? They're not there?
I've called the school. I get text messages on a daily that they are not in school. They're absent every single day. This has been going on for about 3 weeks now. I called the school.
Were they in school?
They're not in Monroe School where they are supposed to be, Your Honor.
Where are
They're
they?
in a
Where do
school
they
in
live right now?
Canton.
Where
I
do they go to
don't know
school?
where
Yeah,
they live. No one's listening
Mr.
to me.
Rodriguez, I'm
I
not gonna argue
don't know where
with
they
you.
live.
If you won't stop talking and arguing with me, we're gonna stop the session.
I'm not
Mr.
arguing,
Rodriguez.
but you're not listening to me either.
Hey,
Your Honor,
keep
I don't
going.
know where they
Keep going,
live.
and you tell me when you're done talking, Mr. Rodriguez.
I'm done.
Okay, my question
Makes
is,
no
where do
sense.
children live with their mother? Do you have any idea?
I don't know. In Canton area, I don't know. Like I said, I've asked. I don't get a response. I asked where they go to school. I don't get a response.
Okay, well, Mr. Rodriguez, you mailed these notices to her at home at the address in Maybe. Whose address is that?
Right. Yeah. So that was the last address she was just at. So out of nowhere, she said she moved. That has yet to tell me where they moved. So I don't know where I'm getting anything, where to send anything. She doesn't live with her father. That's the last known address she was at. She was in the process of selling a house. So if she moved or not, she's a lie. She lies a
Mr.
lot.
Rodriguez, when did you last speak with someone from Monroe Public Schools? Did you call them yesterday to see if the children were in school?
I called them a couple days ago, Your Honor. I keep getting text like I said, I keep getting messages that they're absent every single day. This has been going on for close to 3 weeks now. And she said, and I told Miss Rodriguez, you have to call Custer to at least get them the transcripts and everything, right?
Mr. Rodriguez, when did you last see the children?
I seen them yesterday for 3 hours,
Okay.
and it was my weekend.
Well, your weekends are during the school year, Thursday at 6 p.m. to Monday morning.
No, it's Wednesday,
The holiday.
Thursday.
So
Okay,
did
yeah.
you ask the
Well,
children
I
yesterday,
didn't get the.
Mr. Rodriguez, did you ask children yesterday where they were living, where they're going to school? Your oldest
I
is 10
asked my
years old.
kids.
That tech
I
coach
asked my
won't
kids
tell
that.
you.
I asked my kids that on a daily. They don't know where they live. They don't know the address. They know they're in a new house. They're not sure of the school name. Your Honor, I've been trying. Miss Rodriguez doesn't answer me for
Okay,
the
well, how did
50th time
where
now.
where did you meet to pick up the children yesterday? The Monroe
They
Police
were dropped
Department?
off. They were dropped off by her father because they went to Pennsylvania to a family farm, which was a last minute decision between Chelsea and her father that I found out like last minute. So I didn't get to see my kids till yesterday when I was supposed to have them Friday to Sunday. So I only got to see them for 3 hours, 4 hours. Well, I'm grateful. I'm grateful for the time, but
Who lives
it's
in
just
Maybe? Who lives in this home in Maybe? Is that her father?
Chelsea lived in the home in Maybe. Yeah, she was in the process of
Hold on,
selling out.
Mr. Rodriguez, you just told me she lived in Canton with the children.
I just told you that she had a house in Maybe. We had a house in Maybe I built, and she was in the
Okay.
process of fixing it up and selling it. So that's the address I know she was been at. I don't know. She doesn't answer me, Your Honor. I don't. What
Mr.
else am I
Rodriguez,
supposed to do?
Mr. Rodriguez, the children
Yes,
said
Your
they're not
Honor.
living in Maybe, correct? They're not living in that home. They're living
Now they are
elsewhere.
not living in Maybe. They're in somewhere in Canton area. I'm not sure where.
Okay.
Now they
And they're
are
not going. And they're not
within a couple.
Mr. Rodriguez, and they're not attending Custer School. Is that correct? That's
No,
what they
Your
told
Honor,
you.
they're not. No,
Right.
you're not.
Right. At this point in time, the court's going to suspend mom's parenting time. Ms. Andrus, you modify your recommendation. She's failed to appear. She has not complied with the recommended order. Children need to be. She has no authority to move the children or to remove them from school. So at this time, again, the court, I guess, can adopt the referendum order, but modify it. Children to be in public schools, and mother's parenting time is suspended until she petitions the court.
Yes,
So
Your
you
Honor.
get a copy of this order, Mr. Rodriguez. Now, who's going to watch the children when you're at work, or do you not work?
I have that all set up, Your Honor. My girlfriend's fully intact. I had an after school program already set up. Like I had everything set up for these children and where they were fully watched all day. I never leave my children alone. I have yet to ever leave my children alone. I have everything set up here. But now they were just taken from under their feet and thrown in a complete area where they don't even know.
So, Mr. Rodriguez, your next parenting time is Thursday at 6 o'clock, correct?
It's Wednesday.
Well, today is Wednesday. By the court's review, the last order, the judgment of divorce in December 2022 says your parenting time during the school year is alternating weekends, Thursdays at 6 to school Monday morning. Is this your weekend? Or is this your off weekend?
This is gonna be my off weekend now, but it was Wednesday, Thursday, and then every other weekend. So I'm just kind of confused. But all right, I mean that's fine. But they just go to school now. They're just going to school out there, so Monday wouldn't really make sense, right?
Well, but somehow want to get the children, Mr. Rodriguez, get the children, and you show mom the order that her parenting time is suspended. She's got to petition the court. And
no,
get the children
absolutely.
back enrolled in Custer School.
Okay, no problem. And Your Honor, I truly am. So I didn't mean to cut you off at all. I really didn't. I truly do apologize. I'm just very frustrated. I'm not frustrated at you. I've been doing so much.
All right, Mr. Rodriguez, come down to the front of the court today and pick up a copy of this order from the front of the court.
All right, thank you.
Children are, and mother's parenting time shall be spent until she petitions the court. And get the children back re-enrolled in school. The remainder of the order to show cause is set aside. Both parties should make sure that children are not left alone during the parenting time. Both parties shall complete the SMILE program. Parties shall communicate via text during the children. We can eliminate this provision about the exchange, Ms. Sanders, because the court's suspending mom's parenting time.
Correct, Your Honor.
All right, so come down to front of the court sometime today, Mr. Rodriguez, pick up a copy of this order and
Yes,
somehow hopefully get the children in your possession as soon as possible, get them re-enrolled at Custer.
Yes.
And the mother can talk to him on the phone, but the mother's parenting time is suspended until she petitions the court, until she appears and we have a discussion about what's going on with these children. They can't be
Thank you,
bouncing
Your Honor.
around.
I appreciate it.
Ms. Anderson, any questions?
No, Your Honor. I will fix that right now and re-upload it for you.
Okay, all right. All right, Mr. Rodriguez, try to, hopefully she'll respond and, find out where the children are and just let them know that her parent, well, probably don't want to say too much to her because she may go in hiding. And obviously you want to get those children
Yeah,
back in your possession.
How do you think I should go about this, Your Honor? Should I go get them from
Your
school?
attorney, you can talk to your friend of the court caseworker, or you can talk to an attorney, Mr. Rodriguez, but,
Okay.
maybe reach out to Chelsea's father. If he's been transferred,
Right.
reach out to him and say, you want to see the children this weekend.
Okay.
Okay.
Thank you so much, really.
All right, you're welcome, Mr. Rodriguez.
All right.
Page 1, Casey Cartwright versus Mark Baumgartner. For the record, this matter is before the court and the plaintiff's motion for to show cause, as well as the plaintiff's motion to modify custody and change school district. This hearing is being conducted via Zoom. Present is Attorney Hurston representing the plaintiff moving party, Casey Cartwright. Ms. Cartwright appears to be present. In addition, Attorney Eric Chappell is present, representing the defendant, Mark Baumgartner. Mr. Baumgartner is present with Mr. Chappell. Good morning, everyone.
Good morning, Your Honor.
Parties have conferred with Ms. LaPrade this morning, who has provided the court with the following recommendation that the parties shall follow the front of the court holiday schedule in its entirety. Both parties shall complete the high conflict solutions.com workshop and complete a 100 essay of what they learned. An essay should be delivered to the court as well as the front of the court. The children shall remain in counseling with Jenna Klump at Dr. Newman's office. Father should be 100% responsible for all costs. And finally, the parties will mediate with Ms. LaPrade on June 24th, 2024 at 1:30 regarding other issues, including but not limited to the school district and modification of custody. That is a recommendation. Ms. Nemec, is this recommendation agreeable with your client this morning?
It is, Your Honor. I would just like to clarify that Jenna Klump is actually not a counselor. She's a nurse practitioner at a doctor's office. So she's the acting pediatrician for the parties.
Okay, it does say Jenna Klump, NP, nurse practitioner. So she's a medical provider rather than a counselor. That's clarified. Thank you, Ms. Nemec. Mr. Chappell, is this recommendation agreeable with your client this morning?
It is, Your Honor. Thank you.
Ms. Nemec or Mr. Chappell, do either of you want to voir dire your respective clients regarding this recommendation this morning?
I don't think it's necessary. Thank you, Your Honor.
Same here, Your Honor. I do not believe it is necessary. They both were actively involved in the discussions with the front of the court.
Okay. What about the show cause? Is that the issue raised in the show cause? It's essentially a request for make a parenting time of 1 overnight. Is that correct? Is that going to be also addressed at this June 24th mediation?
Yeah, I think we can reserve all issues to the mediation in hopes of resolution.
All right, so we're going to put this date in the court's calendar. The court will be available. So if you can zoom in after you meet with Ms. LaPrade. If we've got an agreement, wonderful. If we need to schedule an evidentiary hearing this summer, we can do that at that time. Obviously, the court would encourage both parents to visit and investigate the school preferred by the other parent. So they can jointly make that decision rather than have the court as a stranger make that decision. So the 5-year-old will be attending first grade or kindergarten next year? The oldest child.
Kindergarten, Your Honor.
Kindergarten, okay. And they both parties agree that homeschooling that will not continue. Beginning next fall, is that correct? All right,
Yes.
okay.
But Your Honor, I believe that the oldest would actually be attending first grade. She did kindergarten through homeschool with the parties this past year. And then
Okay,
the younger was doing a preschool curriculum.
okay. All right, Cora, keep its, I've made the notes regarding today's hearing. We'll preserve those if we need to address these matters further on June 24th at 1:30. All right, if there's nothing further, the court would like to thank Ms. LaPrade for her assistance this morning. Court will adopt the recommendation. We'll see everyone after on June 24th, sometime later in the afternoon.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome. Parties have engaged in mediation with Ms. LaPrade from the front of the court this afternoon. This review hearing is being conducted via Zoom. President Attorney Hurston representing the plaintiff mother, Casey Cartwright. Mr. Cartwright is present. In addition, Attorney Eric Chappell is present representing defendant father Mark Baumgartner. Mr. Baumgartner is present with Mr. Chappell. Good afternoon, everyone.
Good afternoon, Your Honor.
Sure.
The court's been informed that the parties have made some progress and reached an agreement, I think, regarding parenting time and most importantly, school districts. Are those the primary issues?
Yes, Your Honor. I think we've resolved all pending issues.
Wonderful. Who would like to place that agreement on the record?
I can do that, Your Honor.
Please, Ms. Nimick.
So the parties have two minor children. They agree that their daughters are going to attend Douglas Road Elementary. With regard to expenses related to schooling and extracurriculars, the parties agree they're going to split all of those expenses equally, 50-50. They are going to use our Family Wizard for payment of all expenses. So they already subscribe to the app, and there is a portion of that app that allows them to transfer money back and forth. So that's the platform that they're going to use. There is an agreement that if there are any uninsured medical or dental expenses incurred because the provider that was seen is out of network, whichever party incurs those expenses is responsible for 100% of the same. And then with regard to kind of stepping back to schooling, if there are school trips, field trips, class parties, things like that, the parties will rotate who is going to attend those events for their children, with Ms. Cartwright taking the first event in even years and Mr. Baumgartner taking the first event in odd years. And so the way that it would work is whichever child has the first event, the party who's assigned the first event for that year would take that event. The party who is not assigned the first event would get the next event. If either party is not available to attend one of those school functions, whether it's a trip or a class party, they will let the other party know and offer the other party the opportunity to attend that event. And finally, there are life insurance policies that relate to the two minor children. Ms. Cartwright does not believe that she has them in her possession, and I know she's looked for them before, but she's going to look again for the, I think what we're looking for is the original documentation. She's going to look for that. If she does have it, she's going to make a copy for her own records and give Mr. Baumgartner the originals. But if she doesn't have it, then she won't be able to supply the same. And I believe that that is the entirety of the agreement.
Perhaps if you cannot find them, can someone reach out to the insurance company and request copies of the policies?
We've tried, Your Honor. The only hiccup with it is that the policies were purchased for the children by Mr. Baumgartner's father. So we'd have to, we're just looking to see if we can obtain a copy of them and so each party has them.
So the paternal grandfather is the owner of the policy, is that correct?
That's correct, Your Honor. Yep.
Okay, is he still alive?
He is.
Okay, so that's perhaps that request can be made. All right, thank you. Mr. Chappell, did Ms. Nimick accurately state your client's agreement?
Your Honor, yes, but I would like to just clarify a couple things for the extracurricular, for the school field trips and things like that. It's first by date. So it's the first by chronological date of an event like that comes up. So what that would mean is whichever of the children has their first field trip, That's the first. And then obviously the other parent would have the next one, even if it was with the other child. It's not first for both children. It's first by date in that regard. The other thing I'd like to just note on the record, because I believe it's the party's understanding, is that we are talking about things such as field trips, things that are not necessarily public, or large events like graduations, recitals, and things like that. Of course, the parties should be able to attend those events each, without restricting the other one in that regard.
Ms. Nemec, is that all acceptable, agreeable?
Yes, that's perfect. Yes.
All right, very well. Mr. Cartwright, Mr. Baumgartner, can you both please raise your right hand to be sworn, please? Thank you. All right, Ms. Nemec, if you're going to give it to Ms. Cartwright, please.
Casey, can you state your name for the record?
Casey Amanda Cartwright.
Did you hear the agreement that I just placed on the record?
Yes.
Did you also hear Mr. Chappell's clarifications?
Yes, I did.
Did you have time, or did you understand every part of it?
I did.
And was it an accurate representation of the agreement that you came to through mediation today?
Yes.
Have you had time to think about it?
Yes.
Have you had time to discuss it with me?
Yes.
Okay. Is anybody forcing you to enter into it or coercing you in any way?
No,
Okay. And do you believe that this agreement is in the best interest of your daughters?
I do.
Okay. I have nothing further, Your Honor.
Thank you, Ms. Nemec. Mr. Chappell, first of all, do you have any questions of Ms. Cartwright?
I do not, Your Honor. Thank you.
Questions for Mr. Baumgartner, please?
Yep. Please state your full name for the record.
Mark Lee Bumbarger.
Did you hear the terms of the agreement?
I did.
Understood them?
Yes.
You actively participated in the mediation that brought those terms to agreement?
I did.
You understand you have the right to go to a hearing and a judge could do something far different that could be better or worse for you than what we've agreed to today.
Correct.
But you would like the court to adopt this agreement instead of having to go through those formalities.
Yes.
Do you also believe that this is in your daughter's best interest?
Yes.
Have you had enough time to think about these issues?
I have.
And any question you have has been answered to your satisfaction. So you believe you are fully informed and believe that this is a good agreement and would like the court to adopt it.
I do.
Okay, thank you.
Thank you.
Thank you, Mr. Chappell. Ms. Nemec, do you have any questions of Mr. Baumgartner?
No, Your Honor, but if I could just follow up with Ms. Cartwright, I realized I forgot to ask her a question.
Certainly.
Casey, you understand that you could have taken this matter to trial, correct?
Correct.
And you understand the outcome could have been different.
I do.
But rather than do that, you're asking the court to take the agreement that we've placed on the record and make it in order.
Yes.
I have nothing further, Your Honor.
Thank you. Who will prepare the order?
I can do that, Your Honor.
Thank you, Ms. Nemec.
Well.
The court did receive this morning the essay written by Ms. Cartwright after completing the High Conflict Solutions workshop. Mr. Chappell, did Mr. Baumgartner complete that workshop as previously ordered?
He's halfway through the modules currently, Your Honor. He will complete them, and I'm happy with if Ms. Nemec wants to put that in the agreement, those will be completed and the essay will be forwarded to Your Honor.
Please.
Okay.
And the court likes to evaluate the program. Ms. Cartwright, your essay, you seem to suggest that you thought it was helpful. That was worth your time. Is that correct?
That's correct.
And likewise, Mr. Baumgartner, when you write an essay, let the court know if you think it was a waste of time, be or forthright. Hopefully it will assist, but obviously I want feedback because I'm not trying to penalize people by having them take this class. I'm just hoping that it will assist them. There's enough challenges in life. And you don't need to have some issues with children later on in life. You want them to do well, and it's much better if you can co-parent with Ms. Cartwright. So please provide some feedback, whether you think the program was beneficial or not.
Being halfway through it, I find it very beneficial.
All right, thank you. Thank you. All right, the court would like to thank and acknowledge Ms. LaPrade for her fine assistance in helping facilitate a resolution, as well as, of course, attorneys Nemec and Chappell. And the court would applaud you, Mr. Baumgartner, Ms. Cartwright. You know what's best for your daughters. You don't want the court making these kind of decisions. So I applaud you for reaching an agreement. And again, what might be the best interest today may be different a couple of years from now. So please keep an open mind and communicate in their best interests. So in any event, the court finds agreement by the parents being best interests of minor children, the court will adopt that agreement and will enter the order upon presentment. Thank you again, Ms. Nemec, Mr. Chappell.
Thank you, Your
Please, sir,
Honor.
you can all zoom out. Have a good rest of the day.
You too. Thank you.
Wilkes versus Douglas Hurston II. This matter is before the court on the objections of the defendant, Douglas Hurston II, to a referee recommended order of a child support arrearages and issuance of a bench warrant. This hearing is being conducted via Zoom. It appears that Mr. Hurston has appeared this morning. Good morning, Mr. Hurston.
Good morning.
Can you hear the court, sir?
Yes, sir.
Okay. And good morning, Ms. Hicks.
Morning.
So you appeared, I know you failed to appear at the last hearing. Mr. Hurston, make sure the front of the court, they always keep the front of the court informed of any change of address. So they receive notices.
All right.
Parties have conferred this morning. Ms. Hicks has provided the following recommendation that the authorization for the bench warrant be set aside. And that, Mr. Hurston, you're going to pay $318 prior to the next hearing, which is July 9th, 2024. A minimum of $318. What about a payment for the month of June, Ms. Hicks? Was that discussed?
That is what that amount would be, Your Honor. That's what current support is. He has a $268 per month child support plus a $50 per month birth expense charge. So that's where we came up with the $318. He stated he recently started working for Amazon as a 1099 employee, so he understands he needs to make the payments himself. We discussed the MISDU website and how he can find all the ways to make those payments, as he does live in Detroit and not in Monroe. But he was advised he could make cash payments here at the window. So that's what we want to see, a minimum of current support for him between now and that first available date in July for his June payment. And then we will reconvene from there. He also indicated an intention to look into the potential of filing a motion to modify his support and those types of things as well.
Right. The main thing, Mr. Hurston, don't sit on your hands. I mean, if you don't have the income, you file a motion to reduce your income or reduce your support or get a second job. Now, this recommended order, Ms. Hicks, this morning says you have to pay with $318 prior to July 9th. It seems like you should pay $318 in June and $318 in early July before it's July 9th hearing.
Your Honor, the only reason that that's the next hearing in July is because I am not available on July 2nd to hold a court date usually, and I'm not available the last week of June. So that's the next available date that I'm available for his docket. So I wanted him to make a June payment, and I just didn't want to put it out too soon into June since he's recently employed.
Can you pay two payments of $318 by July 9th, Mr. Hurston, one during the month of June and one during prior to July 9th?
Yeah, I actually plan to pay. Well, I'm selling my vehicle, so as soon as my vehicle is sold, I should be able to pay at least $1,000 or $1,500. So that should be in the next couple of weeks, I'm hoping.
Yeah,
But as far as my job goes, I definitely can make at least, you said 600. I could definitely do 640 by July 9th. I should be able.
You can modify the order, Ms. Hicks.
Certainly, Your Honor.
318 during the month of June and also 318 prior to July 9th. So 318 times 2, you're going to pay that before you appear on the July 9th.
Yep, no problem.
So it's $636. So we're just going to change the amount. So we're going to adjourn this matter. The bench warrant will not issue, Mr. Hurston. Make sure you appear for Ms. Hicks July 9th at 8 in the morning. You can appear via Zoom. And you need to pay $636. That's an order of this court prior to the July 9th date.
No problem.
And you're still in Detroit, correct?
Yes, sir.
Okay, again, if you move, you need to keep front of the court informed of any change of address.
Will do.
All right, do you have any questions, Mr. Hurston?
No, sir. Oh, actually, I applied for Medicaid. So if I get approved, would I be able to get my motions? I forgot the word. Waived?
This court would not waive it. You're able-bodied, you're employed. Why should the taxpayer pay a filing fee for you?
Well, I'm still not making enough money to really pay. I'm
Get
only
a
getting
second job. Get a second job, Mr. Hurston.
Oh, trust me, I've been trying to find a job. It's hard to find a job. So, but
Okay,
I'm
move down to
looking.
Monroe County. We got people, employers are screwing for employees down there, Mr. Hurston. So just see, maybe don't be too choosy. All right.
Well,
Anything further, Ms. X?
Nothing further, Your Honor. I'm uploading that modified order now to your queue and deleting the original.
Thank you. All right, Mr. Hurston, copies order we mailed to you. Good luck. And now concludes here, and you can zoom out. Have a good rest of the day.
all right, you too. Thank you.
Thank you, Judge.
Awesome. Top page 2 of the court docket, Carrie Long versus Jeremy Long. For the record, this matter is before the court on the plaintiff, Carrie Long's motion for her to show cause, alleging that former husband, Jeremy Long, has failed to comply with the terms of a judgment of divorce regarding payment of tax refunds. This hearing is being conducted via Zoom. Is Carrie Long present on audio?
I am. I'm having trouble connecting with the video.
I'm sorry, can you speak up, ma'am?
I said I am. I'm having trouble connecting through video.
Okay, that's fine. You can, as long as you can hear us and we can hear you. Is Jeremy Long also present on audio?
Yes.
All right, good morning to both of you. Two of you have met with Mr. Pratt in front of the court, and Mr. Pratt provided the court with the following recommendation. If adopted, they come over to the court. It says that the respondent, Jeremy Long, shall pay the balance owed of $942 within 14 days of today's date. That's the recommendation. So, Ms. Long, you have received the bulk of this, correct?
Yes.
Okay, so the only remaining balance due to you from the federal and state tax refunds are $942. Is that correct, Ms. Long?
Correct.
Okay, Mr. Long, you can pay this within 14 days. Is that correct?
I'm sorry, Your Honor. I'm having a little trouble hearing you.
The recommendation is that you're going to pay to Carrie Long $942 within 14 days of today's date.
Yes,
Do
that
you
was
understand the recommendation?
Yes, I do.
Are you? Can you do that?
To be perfectly honest with you, Your Honor, I probably will not be able to do that.
Okay, well, can you pay in 15 days, Mr. Long? This obligation is an old obligation. Goes back to February. When can you pay the $942?
I'm currently looking for work, Your Honor. I have an ankle injury that's making it difficult for me to find employment.
How do you support yourself, Mr. Long? You know, you need to maybe sell an asset. You need to maybe borrow money.
I have no one to borrow money from. I'm not really right now. Food stamps, and I don't have an income.
How do you support yourself right now, Mr. Long?
I don't, basically, is what I'm saying. I'm staying with my niece. I don't have rent or utilities at the moment. And
okay, so your niece is supporting you then?
Basically, I guess.
Okay. Do you own any property of any value? Bank accounts?
I have no money in the bank. The only property I have of any real value would be my vehicle.
Okay, well, maybe you need to sell that, Mr. Long. Come on, you received this tax refund, and obviously you pocketed it rather than paying it as you should have back then.
Actually, I received the refund before the divorce was finalized, and some of it had been spent to pay towards bills from when we were still living together. When the divorce was finalized, she knew that I didn't have the full amount, and I agreed to pay it to her by the end of March, and I've just been having a lot of trouble finding work.
Okay, well, Mr. Long, you got to come down to the front of the court. They have a 4-page list of employers who are screwing for employees. You get a job, maybe sitting at a booth at a gas station, where you don't need to worry about just your ankle. Jeremy and Mr. Long?
Yes, I heard.
There are jobs out there, and that maybe if you can't put weight on your ankle, so be it. But you need to pay this $942. So tell me, give me a definitive time frame you're going to pay it.
I really couldn't say. I mean,
I don't want Ms. Long
I
to
mean,
keep coming back. If you're gonna not comply with this order, I don't want Ms. Long to have to bring it back to court.
I don't, could I possibly have until the end of June, time to find a job and get some paychecks and make payments to her?
Are you collecting unemployment right now, Mr. Long?
I'm sorry, I didn't hear that, Your Honor.
Are you collecting unemployment right now?
No, I'm not. I have no income at the moment.
Why don't you apply for unemployment?
Because I don't believe that I would qualify for that.
Okay. You need to come down to the front of the court, Mr. Long, and get that job list. And then find a job that that you can do in light of your sprained ankle. All right, so Ms. Long, what about Mr. Long is asking until the end of June? I guess one thing we can do is can add interest on here.
I was gonna say I don't then what happens is come the end of June? I honestly feel it's pretty unlikely that I will see the money.
Okay.
Then I have to go. Then I have to come back to court. I mean, I could have worked today, and I now have to do this. I'm losing money by having to come to court over things because he doesn't want to cooperate.
All right. Well, we'll. In fact, I'm going to tell you what, Mr. Long. We're going to set a review date. Rather than say 14 days, we're going to set a specific date. We a couple weeks. All right, the court's going to order that this be paid on or before June 12th. And that the court's going to adjourn this matter to June 12th at 9 a.m. So, Mr. Long, this is where you reach out to every person you know. You borrow money from your niece, neighbors, you sell your vehicle, you find it, get down in front of the court today. And if you, the court's not satisfied with your efforts, on June 12th, the court may very well start contempt proceedings. And you can sit in jail until you can post the bond in that amount. Do you understand that, Mr. Long?
Yes, I do.
So if you're not paid by June 12th, at that time, the court will appoint an attorney to represent you, and we can start contempt proceedings. And then which you can be up to 45 days in jail, and then the most likely the court would impose that jail sentence, but you can be released upon posting a bond, a cash bond, in the amount that you owe Ms. Long.
Okay.
I'm not going to play games with you, Mr. Long. You've got to pay this. Now, if you make significant progress between now and June 12th, the court may consider giving you another couple of weeks. But the court at this point in time has already paid this $942 prior to June 12th, and you appear, both of you via Zoom, June 12th at 9 a.m. Mr. Pratt will provide this in a recommendation. You both mailed a copy of this. And we're going to review the status of the matter at 9 o'clock. Are you both available at 9 o'clock on June 12th? It's a Wednesday. Ms. Long, can you appear then?
Yes.
All right. So, Mr. Long, you need to take some significant efforts between now and then if you've not paid it. If not, the court may very well start contempt proceedings. So.
May I ask Your Honor?
Yes. Question?
To of our divorce. When we went through the divorce proceedings, we agreed that the majority of our assets were divided. I was mostly thinking of storage units that I had taken my personal belongings out of and my children's, because there was always running the risk of losing them because he tends to let them go to auction or near to auction, which is the current status of them now. That's why I moved my stuff out.
I'm sorry, what's your question, Ms. Long?
My question is, we had property, some belongings in the niece's basement that he stays in before, when we had moved out of our home, before I moved into homeless shelter. I asked her if I could put things in there. I kind of thought it was neutral ground. I didn't know that he then took possession of it when he moved in a year ago and then just overstayed. I'm sorry,
I do not understand what your question is, Ms. Long. There's nothing in the judgment of divorce about.
tried to get a few things out of the basement, but he's now, police have said that because he lives there, he's a resident, he then, I guess, has ownership of them. And he's saying that I'm not entitled to a few dishes that my mother gave me and some mugs or whatever that I've tried to give the few items that I say I've tried to save out of storage units for him. And I was wondering, because the basement was like neutral ground, it was in my niece's possession, and I still get a few things from there, or is that considered divided assets because he moved in at some point?
Ms. Long, I would suggest maybe talk with the niece, and if she will not allow you access and taking some of those things between you and Jeremy, the judgment of divorce states that each party is awarded the personal property currently in their respective possession. There's no reference to any property being stored. So if Mr. Long's going to play hardball, I guess, and he won't give you some of those things that rightfully, should go to you, and I guess you can play hardball too on this contempt if he doesn't pay that $942. He pays $942. Not much you can do. The judgment of divorce did not address any other personal property that's being stored. Does that answer your question? Okay.
Yes.
Right. All right. We'll see both on June 12th. Mr. Long, I'm telling you right now, you'd be well advised to work with Mr. Long, because she may be willing to give you a little bit of breathing room. And if you play hardball on the dishes or whatever, I guess she can play hardball too on this amount that you owe her. All right. With that, we'll see both of you. We'll mail out a copy of this order. We'll see both of you on June 12th at 9 a.m. And Mr. Long, the court expects considerable efforts and progress on your part.
Okay.
All right. Okay, you can both zoom out.
All right. Thank you, Your Honor.
Welcome. Good morning, Ms. Brower.
Good morning, Your Honor.
Okay.
Is now in session. Middle of page 1, Carrie Long versus Jeremy Long.
For the record, this matter is before the court to review some post-judgment issues regarding payment of a balance due from the defendant Jeremy Long to Carrie Long. This hearing is being conducted via Zoom. Are you Carrie Long?
Yes. Yes, I am.
Good morning. Is Jeremy Long present on audio?
Yes, I am, Your Honor.
All right. Good morning, Mr. Long. So I guess the $1 million question is, has the $942 been paid to Ms. Long?
No, not in full.
I'm sorry?
I said no, not in full.
You keep breaking up. It has been, yes or no? Has it been paid in full?
No.
Okay. Have you received any of it?
$300 on Monday.
All right. Mr. Long, you've got to the end of the day to pay this off.
I'm sorry, Your Honor, I didn't catch that.
You have until the end of today to pay that off.
Okay.
This is a
Your Honor,
court order. You're to pay this, or actually, you should have paid by now. It's supposed to pay it by June 12th. Today's the 12th of June. Play games with you, Mr. Long.
I'm sorry, what was that?
The court will not play games with you, Mr. Long. Can you pay the balance of that this afternoon?
Could I say something, Your Honor?
Can you answer the question? Can you pay that balance this afternoon?
I can take my van to Braunlich Ford in Toledo and sell it today. The only ride that I have back from Toledo would be after the bank's closed. I could deposit that and have the money for her first thing in the morning. I'm not sure that I could. I mean, I can sell the van today, but they pay me in a check, not cash. So could I have until tomorrow morning, please?
Okay, so what are you going to do? You're going to make an electronic transfer to Ms. Long's account, or are you going to send her, give her a cash or a check, or how are you going to make that payment?
I'm going to sell the van today, and they will pay me by a check. I will deposit it in the morning and withdraw cash, and I can pay it to her in the morning, or whenever I guess is convenient for her tomorrow.
That balance will be $642. Is that correct?
Yes.
All right. All right. The court's going to adjourn this until tomorrow. Are you both available tomorrow? I want to confirmation this has been paid.
Yes.
Let's see what time we do tomorrow. Okay, the court will adjourn this matter to would note that Ms. Brown, if you can prepare an order that only $300 was paid, and the parties shall Mr. Long indicates he'll pay the balance of $642 this afternoon. So adjourn this matter to 8:45 tomorrow morning.
Okay. Thank you.
Mr. Long, make it happen.
Yes, I'm sorry, Your Honor. I'm not sure. Maybe I'm not trying to be difficult. I wouldn't be able to deposit the check and get her money until after the bank opens in the morning.
Okay.
The only ride that I would have back from Toledo, I wouldn't be getting back in town until right when the credit union is closing at about 4:30. So I would just need a little time to go to the bank when they open in the morning to deposit the check into my account and withdraw the $642 to pay to carry.
Well, will they let you withdraw that immediately?
I'm sorry?
Will they let you withdraw that immediately? Sometimes they require that to be deposited for 24 hours. I don't know.
I'm not sure about that.
Or is it better for Friday? Okay, how about print 8:45 on Friday then?
Okay.
Friday, June 14th.
Okay.
So make a note of that, Mr. and Ms. Long, if you can both zoom in at 8:45, June 14th, and it should be real quick. Just want to confirm that their remaining balance 642 has been paid.
Okay. Yep.
Any questions, Mr. Long?
No, Your Honor.
Okay, we will see you then. Please make it happen. We'll see you on Friday morning, June 14th. Just confirmation from Ms. Long has been paid, and that'll be done.
Thank you.
Okay, keep the court Zoom ID number and make a note because you're not going to receive notice of this hearing date in the mail by then. So just make a note and zoom in at 8:45 on Friday morning, June 14th.
Okay.
All right.
Okay, all right. That will conclude this hearing. We'll see you on Friday morning.
Thank you.
Welcome. Ms. Long, did you receive the final payment from your former husband?
I did. Yes. Thank you.
I guess perhaps we can call the case. I don't know if I guess we'll call the case. I don't know whether he intends to appear. Do you know whether he intends to appear this morning?
I assumed he would, but
Okay, we'll give him a few minutes. Ms. Long, do you have a phone number for Jeremy? Do you want to text him?
yes, I can.
And again, from your standpoint, everything is done, correct? No need for him to appear?
Correct. Yep.
Well, I guess we'll call the case. I don't want to keep you waiting. We'll call the case and we can confirm that on the record. And then you can text him and just say that the judge confirmed that everything's been paid and taken care of and you don't need to appear this morning. Maybe he forgot it's because he's about 8 minutes late. So we'll call the case.
Okay.
For the record, this matter is before the court for a review. The parties were before the court on this post-judgment issue on Wednesday of this week, June 12th. To determine the status of payment of a final sum due to the plaintiff, Carrie Long. The court ordered Mr. Long to pay the remaining balance that was owed to her before today's date in order that he appear this morning at 8:45 for a continued review. Present this morning is the plaintiff, Carrie Long. Mr. Long has not appeared. It's a little bit late, but perhaps it's not necessary. Ms. Long, can you state your name for the record, please?
My name is Carrie Long.
Okay. And Ms. Long, your former husband, Jeremy, did pay you the remaining balance of $642, I believe yesterday. Is that correct?
Correct.
Okay. Did you get paid by check?
No, I mean, his amount owed is absolved. He made a deal. Our daughter needed a vehicle, so I helped her with that, and it's all resolved. I'm happy with it. I will have my money.
All right. I just didn't know if, for example, you got to receive a check and the check's not been endorsed yet. That's a bad check. It bounces. I'm just trying to avoid having to come back again.
Right.
But from your standpoint, the obligation of Mr. Long pursuant to the judgment divorce has been fully satisfied. Is that correct?
Correct, yes.
All right, do you have any questions for the court?
Nope, I don't. I really appreciate it.
Okay, all right, if you want, you can just text Mr. Long, tell him that you've appeared this morning, confirmed everything has been addressed, and no need for him to appear.
I will do that.
Ms. Long, you can zoom out, have a good rest of the day.
Thank you. Have a good day.
Page 2 of the court's docket, Nicole Roberts versus Lee Madera. Was before the court on the objections followed by Lee Madera to a default judgment of support. Mr. Madera is present this morning for this Zoom hearing. The plaintiff, Nicole Roberts, has failed to appear.
Your Honor, my records show the friend of the court mailed his objection due to her having a confidential address, and I also called her phone number that we have on file.
Thank you, Ms. Andrus. This matter was scheduled for hearing at 10:30. It's now almost 11 a.m. Ms. Roberts has failed to appear. In front of the court, mailed her a copy of this. And, the certificate of mailing is blank, Ms. Anderson, the court file, but you have something in your file that shows that the front of the court did in fact mail this objection notice of hearing to Ms. Roberts.
And I can send you a copy as well, but it looks like on 4/23 it was sent.
Okay. It should be part of the court file.
Would you like me to send you an email?
No, I do see that now. Ms. Lehman, on April 23rd, did file a copy of defense objections and to the recommended order for today's hearing at 10:30 to Ms. Roberts, confidential address. Okay, court satisfied. Service has been effectuated. And sir, you are Lee Madera, is that correct?
Yes, sir. Yes, Your Honor.
And for the record, you are currently incarcerated in the Wayne County Jail, is that correct?
Yes, Your Honor.
Okay. And it's not clear what your objection is to this recommended order, other than the fact that you could not appear because you were incarcerated at the time of the hearing on April 8th, 2024.
I'm objecting to the decision of the sole physical and legal custody.
Okay.
I understand about the physical custody, how that works, because I have a son with another woman, but I didn't want to lose my legal custody at all just because I wasn't able to make that hearing because I was incarcerated. I stayed at home raising those two little girls. She worked most of the time, and I haven't been able to see them. And since the last time I seen them was November 4th, 2022 or 23.
Okay. When's the last time you had contact with those daughters?
November 4th, 2023. She let me see them for her birthday. It was on her birthday. She let me get them at my aunt's house, and I had them. She heard because my daughter said hello to my current girlfriend on a video. My daughter told her mother that she said hi. Then she blocked me on everything, and she took the kids and has not let me see them since.
Yes.
Okay. Well, the issue of parenting time has been referred to the front of the court for a recommendation, so you want to look out for that, Mr. Madera. Make sure you get your mail on the Versailles Street in Romulus. If not, you need to change your address. The front of the court's going to conduct a parenting time investigation. They're going to make a recommendation. If you disagree with that recommendation, parenting time, you need to file a written objection. Okay.
Okay.
Be proactive. But your primary objection this morning is that you think you want to share joint legal custody of the two girls, correct?
Correct.
Okay, and you have no problem with mama having sole physical. You just want to. Sole legal, of course, means that you share equally any major decision concerning the welfare of the girls, like elective surgery, things of that nature.
Your Honor, I just want to be able to make decisions with them, and I just want to be able to see them is all I really want. Just want to be able to see them.
I'm sorry, how old are the girls?
5 and 7.
Okay, why have you not seen them or had contact with them since November?
Their mother won't let me see them. She won't let me see them.
Well, why don't you take action, like, for example, file a complaint?
Because this is just the first, that's what I've been doing. I didn't know anything. I didn't get my mail for the thing. That's what I'm doing now. That's why I filed this objection, because I didn't know that I lost my rights until she filed on Facebook praising that she got sole physical and legal custody, and that I never would get to see the kids again. That's how I found out about this whole court thing.
Okay, right. Mr. Madera,
Yes.
She's obviously, your children are receiving public assistance. Because of that, the front of the court started this complaint. But you could have started
Right.
your own complaint asking for an order of custody parenting time back in November. Why didn't you take steps to do something? File an
I'm
action
sorry.
yourself.
Because I didn't really know how to in the beginning, Your Honor. I'll be honest with you. I didn't really know how until I started contacting. I thought she was being friendly and she was letting me see them once in a while and video them and everything like that. But then she just stopped. And
Okay,
then
so
she told me.
Prior to
Right.
November, did the girls ever live in your household?
Yes, they would come and see me. Yes.
Did you ever take them to the dentist or the doctor or the pediatrician?
Not well until like before we separated. Before we separated, yeah, I did.
I'm just asking, during their lifetime, did you ever take them to a doctor, to a dentist?
Absolutely, all of them. Yes.
Okay, did they ever stay overnight in your home?
Yes, Your Honor.
All right, well, she's failed to appear, so the court will grant the relief requesting Ms. Madera. The court will adopt and modify the recommendation, and then the two of you shall share joint legal with the physical custody to the plaintiff mother.
Okay.
And again, be on the lookout for that parenting time recommendation, because if you disagree with it, or you can always file a motion for parenting time. So look out for that recommendation. If you disagree with the recommendation on parenting time.
Can I ask when would that? How does that work? How does that comes in the mail and it tells her like when I get them for the weekends or something like that?
Well, the further court's going to contact you, and maybe they've tried but unable to do so because you're incarcerated.
Okay.
Ms. Sanders, do you have any knowledge of the status of that parenting time investigation? I'm sorry, you're muted, Ms. Andrews.
I do not, Your Honor. It's currently in the process.
Okay.
My next
Mr.
court
Madera,
hearing is. Go ahead.
When will it be released from jail, Mr. Madera?
My next court hearing is on June 14th. I'm looking to hopefully be released that day, but not much sooner after that.
Okay. Well, the court suggests, I don't know if you piece of paper, and you want to call Catherine Scott. She's the friend of the court personnel that's going to conduct this investigation, because she may be trying to reach you, and if you're not responding because you're in jail, then she's going to say, we couldn't find Mr. Madera.
So is there any way I can get Mrs. Scott's phone number, please?
Yeah, I will give you do you want a phone number or email address?
Phone number and email address. That'd be great. The deputy is getting me a pencil right now.
.org, yeah.
Yes. Monroe, MONROE.org.
Oh,
so the court suggests email her and let her know your situation and tell you do want to participate in this parenting time investigation, Mr. Madera. Also, make sure you're receiving your mail on this Romulus.
Okay? Is there any way I can update it? Is there any way I could update a second or update an address right now with the court or anything?
You need to do that in writing with the front of the court.
Okay, not a problem.
Now, so who lives there? Can you still get mail there? Can your girlfriend get mail there? That's
yeah, it's my aunt. Well, that's my aunt's address. I was going to actually give you the address where I'm currently living with my girlfriend. Yes.
Okay, we'll have your girlfriend to check regularly for that mail, because copy the order that the court's entering today will be mailed to that Versailles Street address. So we need to copy that.
Okay, because I left with Cindy. Cindy, I don't know I don't know if she's your secretary or something, but we gave her a new address as well.
Well, you need to notify the front of the court in writing, not my office, but the front of the court in writing.
Okay.
They do all the mailings.
Gotcha.
All right. So the court again will note that she has failed to appear this morning. Name Nicole Roberts. And the court will enter an order that adopts the recommended order but modifies it to grant the two of you joint legal custody. Any questions, Mr. Madera?
So when you say the parenting time recommendations, those are just recommendations. Does she have to abide by that?
Yes. Well, unless she files a written objection, the front of the court will complete an investigation. They're going to issue a written recommendation after they investigate it, and you both have a time frame which to object, to file a written objection. If you don't, it becomes an order of the court.
Okay, so that's like how Wayne County does it with the mediator and all that?
Well, there's no mediator. There's a caseworker. Her name is Catherine Scott. She's going to contact you. She's going to contact Ms. Roberts. If she can't contact you, she can put that in the report. I can't get hold of Mr. Madera.
Okay,
so you want to initiate the contact with her because she doesn't know where you're at.
Okay, I got it. I appreciate that.
And if you can't reach her and you get that recommendation, you've got 21 days in which to file a written objection. So have keep an eye on the mail that's being delivered to Versailles Street, okay?
Okay, yes, sir. Yes, Your Honor.
All right, you can zoom out, sir.
Have a great day.
The court is awarding you joint legal, Motherwell fiscal. All right, good luck, sir.
Thank you.
Thank you, Ms. Andrus.
Thank you, Your Honor. That new order should be in your queue.
Conference matters before the court for a continued pretrial conference subsequent to continued mediation with Attorney Jeffrey Pepper. Present are both parties, as well as Attorney John Danielski and Attorney Michael Jones. Good afternoon, good morning, everyone, almost afternoon. Mr. Danielski has informed the court that the parties have discontinued the mediation for today, but have no final resolution. Is that correct?
That is correct.
Okay, where do things stand now? Is there another continued mediation with Mr. Corber, with Mr. Pepper scheduled?
We didn't schedule one yet. I mean, we did make a lot of progress, much, I mean, more than last time, but I don't know. But we haven't scheduled another mediation yet. Seems we're in an impasse.
Okay, do you want a trial date?
I believe trial date would be probably the best way to go at this point, Judge.
We do have some depositions set, and there was some medical evidence that my client wanted to gather. So hopefully we didn't schedule it right away, Your Honor.
Okay, the court will not schedule a trial date until discovery is completed and concluded. So how many months do we need to complete discovery?
60 days, Your Honor.
Okay. Sir, can you get the calendar, please? Sure. Let's get another meeting, pre-trial date. All right, do we need the calendar schedule another pre-trial date? What are the primary sticking points? The court noted the initial pre-trial conference, the issues were spousal support, real and personal property division, pension benefits, and debt division. Are all those at issue?
I don't think that is an issue, Judge.
I'm sorry, Mr. Jones?
I don't think debt is an issue.
Okay. Okay, what about real property? How many parts of real property do we have?
We've got a house and we've got a timeshare, Your Honor.
Okay, well, we're going to liquidate those. If we can't reach agreement, that's what the court's going to do at trials, liquidate those. It's real easy to divide cash. So any reason why the court should not order today that the real estate be listed, the timeshare and the marital home?
I'm not opposed to listing the marital home, Your Honor.
Well, the timeshare as well. If one's not going to about there's an interest, let's liquidate them.
Judge, we've had two appraisals on the real property with the home located here. We've taken an average of the two. My client would like to be awarded the house. I don't know that that's really going to be a sticking issue.
Well, Your Honor, she wants the house too, so we're not opposed to listing it if that's what Your Honor's going to do anyway.
Well, which party's willing to offer the most? I mean, if they want to bid against each other, then that's what it's going to be. If they don't want to liquidate it.
They might. We didn't really get that far into mediation. They might be able to bid against each other.
Timeshare. Why can't we liquidate that?
Cheryl, you heard what the judge said. Do you have any objection to putting the timeshare up for sale?
No.
I don't, Jim, you don't either, do you?
No, I didn't make an offer to buy it, but if we have to sell it, we have to sell it.
Well, if we cannot agree upon a value, and these things should be addressed ahead of time. I'm just, if we proceed into trial, I'm not going to order this time, but if the parties cannot agree, then on the buyout of those things, then that's what's going to happen in trial is liquidate.
Sure.
So that should not hold up a settlement. Okay. So what's the sticking issue? Is it spousal support?
I don't think that's a real sticking issue at the moment, Your Honor. It's more the district. I mean, they've got money. There's an argument about what's premarital, because there's some premarital retirement plans. There's a personal injury settlement that my client received, and that was used to pay off the home, not the entire home. The home is, we don't know, the home roughly, I mean, I don't know if these appraisals are correct, roughly $460,000 to $500,000 home roughly, but she paid off a mortgage about 78 grand. She actually, we couldn't use Mr. Godfrey as a mediator because he actually did her personal injury settlement. So she received approximately, these are my rough notes, it was roughly $150,000, might have been more. Cheryl, if I get that wrong, excuse me. And she paid off about $78,000 on the mortgage, and then she bought that timeshare with it, and then she bought 3 acres of land near the property. So there's an argument about what she should receive for her personal injury settlement, and then there's argument about premarital. There's a bit of an argument about wasting money, and there's a cruise, an argument about a cruise. The big ticket items, Your Honor, are the approximate 1.8 million they have in the bank and in the home. Those are the big ticket items.
Well, it appears to me that Ms. Corber, even if she won the lottery and she put that into a marital asset, that's a marital asset. It's commingled. So
I'll mention
she's entitled to reimbursement of what she contributed toward the marital estate. The court doesn't see that, Mr. Danielski.
Well, I'm telling you, these are the things she's asking for, Your Honor. I'll certainly share. She's listening to you right now, so hopefully she'll take that into consideration regarding what you said.
All right. So again, you want another 60 days to conclude discovery. Is that correct?
That is correct.
Okay. So let's look at some pretrial days in August. It seems like the parties have invested a lot of time and effort with Mr. Pepper. He's familiar with everything. I'll leave it to the parties. I'm not going to order that they continue mediation with Mr. Pepper, but it seemed to make some practical sense. To minimize the cost of associated with litigation and the uncertainty associated with litigation. Okay, you want looking at some Fridays in August, August 2nd, August 9th, August 16th. Any preference, council? August 23rd. Pick a Friday in August. It's a ways off.
Any Friday is available to me, Judge.
I prefer the 16th, Your Honor. I have a trial in Otsego County on the 2nd, and
okay.
I do have something on the 9th, so I prefer the 16th.
Okay, Mr. Jones, I work with you. Mr. and Mrs. Corber, anything, everyone will be available on Friday, August 16th. It'll be a Zoom pre-trial conference. Ms. Corber's indicating she's agreeable with her. Mr. Corber, will that work with your schedule?
That's fine.
At what time do you prefer? The court prefers mornings.
I prefer first thing in the morning.
Okay, 8:30?
Sounds good to me.
9 o'clock. The court would prefer 8:30.
8:30, I'm fine with. Mike?
All right.
8:30, I'm fine. And Judge, I just want to state my client has no objection to continuing on with mediation with Mr. Pepper if they're willing.
I need to ask my client. I certainly don't want to switch mediators. He knows everything, and he's certainly been working real hard. And we are a lot closer today than we were the last time. So I just have to ask my client about it, Your Honor.
Very well. And of course, Mr. Pepper is more than welcome to consult the court. Sometimes Mr. Godfrey, with the permission of the parties, has consulted the court on a certain issue, which has helped him facilitate resolution of divorce cases. So you can mention that to Mr. Pepper if in fact he's got the consent of everyone. If he wants to contact the court to discuss a particular issue with the court, then the court would certainly be willing to give him some guidance in terms of what the court might be inclined to do at a trial. So the court would encourage him. He's got a lot of time. There's been at least 2 sessions, Mr. Pepper. He's very capable. The party's already got some significant investment in Mr. Pepper without having to reinvent the wheel. So the court would encourage the parties to continue their discussion with Mr. Pepper after discovery has been completed. So the court will mail out notice of a final pretrial conference, August 16th, 8:30 a.m. via Zoom. And if we don't have resolution, if there's some resolution in the interim, contact the court. The court's always available to take an agreement on the record, so don't hesitate. We don't need to wait till that August 16th date. If we don't have a resolution by August 16th, at that time, the court will schedule a trial date.
Thank you, Your Honor.
Thank you, Judge.
Anything further then? If nothing further, then thank you for appearing. Now we can zoom out. Have a good rest of the day. Record this matters before the court for a continued pretrial conference, same as being conducted via Zoom. Present is Attorney John Danielski representing the plaintiff Cheryl Corber. Ms. Corber is present. In addition, Michael Jones, attorney representing the defendant James Corber, is also present, as is Mr. Corber. Good morning, everyone.
Good morning.
Morning.
Parties were last before the court on May 29th. The court was advised that the resolution is a little closer, but they had not yet completed discovery. Has discovery now been completed, Mr. Danielski, Mr. Jones?
There are a few lingering things that I think I can work out with counsel, judge, and discovery has not been a problem. It's just that there's a lot of different accounts, and the estate is quite large.
Okay. Well, we've had motions to compel, so there's obviously been issues with discovery, Mr. Jones.
You can dismiss that motion.
All right. Court's informed that you're going to mediate with Attorney James Mena next week or within the near future. Is that correct?
That is correct.
What today is at what time?
Wednesday at 1 o'clock.
I'm sorry?
Wednesday at 1 o'clock.
Okay. All right. The court then will continue. We're going to continue this pretrial conference to Wednesday afternoon, subsequent to that mediation. Obviously, while things are fresh on everyone's mind. Did that work there on schedule?
Yes, Your Honor. Log in after we meet with Mr. Mena, correct, Your Honor?
Yes.
Nice.
Will that work with your schedule, Mr. Jones?
Yes, Judge, I sent you an amended ex parte order. It's my understanding counsel is not objecting to the entry of that order. We would ask that it be entered. I emailed it to you yesterday afternoon.
Haven't seen it, and you can't email things. You need to mail it. Mail it to
okay.
We don't have them e-filing yet, and we don't print out orders that people email us. You got to be on your paper, Mr. Jones.
I will get you the order, Judge.
So has Mr. Danielski approved it?
I will get his
approval. I don't have it. You can sign my name.
Okay. So Mr. Jones, court suggests fax it to Mr. Danielski. He can sign it. He can fax it back to you, and then you can submit it to the court.
Thank you, Judge.
But I've not seen it yet. All right. We'll see everyone then sometime in the afternoon of August 21st. Obviously, if you mediate past 5 o'clock, then we can perhaps appear on Thursday morning. The court will be available all next week, but the court preferred to do the pretrial conference subsequent to the continued mediation on August 21st. All right. Is there anything further the court can do to assist this morning?
No, Your
I
Honor.
believe so, Judge.
All right. Right. Thank you all. And hopefully the parties can work through their own resolution, which is far better off than have the court decide these matters. So it's everyone then the afternoon of August 21st. All right. That will conclude this pretrial. You can all zoom out. Have a good rest. For the record, this matter is before the court for a continued pretrial conference subsequent to another mediation session. I believe the parties mediated with Mr. James Mena this afternoon. This hearing again is being conducted via Zoom. President is Attorney John Danielski, representing the plaintiff Cheryl Corber. Ms. Corber is present with Mr. Danielski. In addition, Attorney Michael Jones is present representing the defendant James Corber, and Mr. Corber is present. Good afternoon, everyone.
Afternoon.
Afternoon.
Appears from the face on everyone that the parties have not made any progress toward their own resolution. Is that correct?
Correct.
We haven't been able to settle it, Your Honor.
Okay. So at the end of the rope, you want the court to decide the matter?
Yeah, not really, Your Honor, but I think we have no choice at this point.
Okay. Ms. Nancy, if you come out with our calendar, please. What are all issues still on the table? Spousal support, real and personal property division, pension benefits, debt division? Have they been able to narrow down and eliminate anything as an issue?
Yeah, I would agree with Mr. Jones.
I'm sorry, I didn't hear Mr. Jones' response.
No, we have not, Judge. There's been nothing resolved in
All
this
right,
case.
okay. Ms. Nancy, can you come off the calendar, please? How many days do we need for the trial?
Probably at least 2, Your Honor.
Okay. Has all discovery been concluded?
Yeah, I mean, I'm not asking for anything at the moment. I don't think Mr. Jones is. There might be some subpoenas that'll go out, but I don't think the parties at the moment are asking for things from the other side.
No, the only thing outstanding that I still need is the statement from Social Security.
Okay.
There is one issue if we can bring to your attention.
Has that been subpoenaed, the Social Security statement, or is Mr. Danielski going to provide that?
I just asked it yesterday from counsel. I believe that he will voluntarily provide that.
My client's indicating to me it's in the file. I'll have to dig through the file. If not, I'm sure she can get it from Social Security. There's a way to do it online, but she's nodding her head. I asked her if it was in the file. She said yes. So I'll look. I thought I'd sent it to Mr. Jones before, but I'll go look, Your Honor.
Okay, so it sounds like discovery has concluded then, correct?
Yes, except maybe some subpoenas just to on some bank statements that I think the parties might send out, but I'm not asking for anything from Mr. Jones at this time. I don't think he is for me either, other than what he just indicated, Your Honor.
All right, the reason I'm asking is I'm going to set a trial date, and the court will not adjourn that trial date. So I just want to make sure the parties are ready to go.
Well, we've discussed it. I'm sure Mr. Jones did. I discussed it with Cheryl. I said, Judge, going to set a trial date today. So she understands, Your Honor.
And of course, it could be a result that neither party likes very often at trial. But if they cannot agree, then the court will make that decision. So we need 2 consecutive days. That'll be an in-person trial. The court's motion dockets are Tuesdays and Wednesdays, and in order to have 2 consecutive days, we can either would you prefer a Thursday and a Friday or a Monday and a Friday? If we're gonna do 2 days in the same week.
It's
right. Try to be consecutive Thursday and a Friday.
It doesn't matter to me, Your Honor, either way.
How about October 31st and November 1st? It's a Thursday and Friday. We'll block out those 2 days. I won't schedule anything for those 2 days.
Your Honor, I've gone on vacation. I haven't had one in 4 years. I'm leaving on October 17th and coming back November 10th.
Judge, I was going to ask because I know counsel's schedule and I know my schedule. I was going to be asking for a December date. I'm not going to be available at all in the month of September or November, and it's my understanding everyone else has got something going on in October.
So I'm asking for a date in December?
Yes.
I think parties want to get divorced before then, but if in fact you want to get a trial date in December, we can do that. How about December 5 and December 6? The first Thursday and Friday in December.
Looks good to me, Your Honor.
Good for me too, Judge.
Mr. Corber and Ms. Corber, does that look? Does that work with your schedule? December 5 is a Thursday and a Friday.
Yes.
All right, Chrome out notice. It'll be an in-person trial beginning at 8:30, December 5. And then continuing if necessary at 8:30 on December 6. Court will request to the parties exchange witness lists and exhibit lists and provide the copy to the court as well as a trial brief. How about on or before November 22nd? That's the Friday before Thanksgiving. Will that work? Is that a?
Works for me, Your Honor.
No, that will work. Get it done.
All right, Coral Mail notice, again, in-person trial, December 5, 8:30 a.m. and continuing into December 6 at 8:30 a.m. Exhibit witness lists shall be exchanged and provided to the court, as well as a trial brief to the court addressing the issues to be filed and provided on or before November 22nd, 2024. Court mail notice in that regard. Court would urge the parties to continue their discussions. Obviously, I think you've had a couple mediations and try to build upon that. Without question on both sides, there's a significant advantage to have a negotiated agreement. Spousal support, of course, if that's an issue, that will be open-ended from Mr. Corber's standpoint. He's got to understand that. The way he can cap that is to have a negotiated resolution on spousal support. We have a timeshare and a marital home, is that correct?
Yes, Your Honor. And there was an issue regarding the timeshare I was going to bring up when Your Honor's ready. But yes, there's 3 acres next to the marital home or near the marital home as well. So it's three pieces of land.
Easier to divide cash. So I mean, if in fact the court suggests for us look at maybe liquidating the timeshare and these 3 acres. Now, Mr. Corber shaking his head no. Mr. Jones, are there 3 acres adjacent to the marital home? Is it just vacant land?
You know, Judge, I really don't know the answer to that. I know the home is situated on 6 acres of land. I don't really know how it's laid out.
My client says it's vacant land adjacent to the home.
And who's living in the marital home right now?
Mr. Corber is.
Okay. So obviously he wants to retain the marital home, presumably?
Yes.
Has it been appraised?
Yes.
Okay. Do we have an agreement on the appraisal or are we going to get competing appraisals?
There's appraisals. I don't think we're going to get any more, Your Honor, than that. We have 2 appraisals, so that's what's going on. We have one and they have one. So for mediation purposes, we were averaging the 2. They were about 40,000 apart.
Okay,
that's correct.
And Mr. Corber wants to retain that marital home. Is that correct, Mr. Jones, about her interests?
Correct.
All right. Okay.
I didn't want to interrupt you, Your Honor. There's a timeshare in Florida, Key West. Mr. Corber used it last October. We were hoping that they would, Mr. Corber would agree for my client to use it this October. Apparently, there's not an agreement. We were hoping that they would agree to that. It's being paid for out of marital funds. My client wanted to go down there in October. They're not living together. They don't get along. That's why they're getting a divorce. And we were hoping that he would agree to that since he used it last October.
Mr. Jones, what's your client's position?
My client's position is that he's made plans. He intends to go down there. He intends to use it. She's more than welcome to come down if she wants to come down. He invited her to come down last year. She decided not to. And it's not necessarily, it's a little bit more complicated. My client lessened the amount by $2,000 a month coming out of the budget, out of the, $3,000 a month. Coming out of the IRAs and the 401ks because my client is not employed and he's not receiving Social Security funds at this time. And because of that, he has been able to do less. So it's not necessarily coming out of the marital estate, so to speak. So he's more than willing to share the timeshare with her if she wants to come down. If she doesn't, that's her option. They both own it.
Obviously, they're going through a divorce right now. Mr. Jones, obviously, she's not going to want to join him in the Key West in October. Why don't the parties simply liquidate it?
Well, that is certainly my client's fine with liquidating it, but while it's in use, she'd like to use it. This is a 30-year marriage, Your Honor. Everything's in the marital pot, and I could get into all kinds of stuff I really don't want to on the record regarding what Mr. Corber's been doing with his funds. But the point is, he used it last year. It would be fair that she use it this year. But
right. Well, it's really not before the court this afternoon, Mr. Janeski. So I would suggest filing a motion, and then you can address the expense, who's been making the monthly expenses. You suggest he's paid out of marital funds. Mr. Jones saying it's not. So maybe you can motion that up and notice for hearing. Mr. Jones can properly respond. The clerk can make a decision. And the court may simply, I'm inclined to simply order that to be liquidated. I mean, then it's no longer an issue. Now, if Mr. Corber's already committed to an expense through the end of the year, then that's different. Maybe they can split that week. I mean, that's a possibility. Can they each spend 3.5 nights there separately? But in any event, it's not for the court this afternoon. Notice that up so Mr. Jones can properly respond to that request, Mr. Danielski. It's a legitimate issue if your client feels strongly she wants to go down there.
All right, Your Honor, I appreciate it. I know it was, brought it up at the last minute here, so we'll do that if need be, Your Honor.
Okay, and maybe that's a starting point to agree upon some resolution. Mr. Jones?
I understand that, Judge.
Okay, all right, that will conclude this hearing. We'll send out notice.
Thank you, Your Honor.
Thank you.
Welcome. We'll call the case of John Murphy III versus Catherine Olivia Avery Dugo. For the record, this matter is before the court this afternoon on the plaintiff's motion for possession of the minor child. And this hearing is being conducted via Zoom. Present is Attorney Carmen Moyer, standing in for Kim Kuhn this afternoon, representing the plaintiff John Murphy III. Mr. Murphy is present. Is Catherine Olivia Avery Dugo present in audio? Appears that she is not. Good afternoon, Ms. Moyer. Have you had any contact with Ms. Avery Dugo at all?
Good afternoon, Your Honor. No, we have not. And the last time my client had any contact with the defendant was May 7th, when he was able to FaceTime his child. He believes that the child was in a hotel room. We believe that the mother has fled the state to Nevada because that's what she told father she was doing. That's what she told the process server she was doing. And she uses the same Corber discount card that my client does. And there has been recent activity in Nevada on that card, that Corber card. So we believe she's fled the state, Your Honor.
Right.
She was personally served on April 12th at her home in Toledo, Ohio. At the time that she was served, she refused to release the child, even though your order stated she was to immediately return the child. My client was present in the vehicle. There were 3 police officers present as well. She was verbally hostile, told the service of process that she was moving, and we haven't heard from her since. The last time my client has seen his 3.5-year-old daughter was April 9th. The parties were never married, but there is an acknowledgement of parentage. The child was born here in Michigan in Wyandotte at Henry Ford Hospital in September of 2022. The parties resided together in Wyandotte until mom relocated to Ohio in July of 2021. My client has been the primary caregiving parent since that time. The child has lived with him, has a bedroom and a home with him, has her all her own stuff there in dad's house. Dad had probably about 90% of the overnights. There were no prior court orders until you entered the ex parte order on April 12th to return the child immediately to dad, and mother did not. So we're asking the court, and I actually, Your Honor, I know I'm talking a lot, but I wanted to get this all on the record. I drafted a proposed order which grants my client sole legal and physical custody of the child temporarily, has the standard language about not changing the domicile, and authorizes law enforcement to arrest the defendant for violating your order and to pick up the minor child and return him. I drafted it in a particular way to establish the jurisdiction of this court and address the issues of notice and opportunity, because I suspect we may have to try to track her down in Nevada and register this order and have it enforced there, unfortunately. So I think Ms. Andres has attached a copy of that order to the recommendation, and that's the order I'm asking the court to enter.
Right. Thank you, Mr. Moyer. I think you've answered one of the court's questions, and I did not know until just now that Mr. Murphy was unable to secure possession of this minor child. The court would note that, for the record, that next order was entered by Judge Lohmeyer in this court's absence on April 12th, which prohibited the defendant mother from moving more than 100 miles away and placing the child in the plaintiff's possession. The court file reflects that a copy of that, the notice of hearing, was mailed to Miss Avery Dugo on Greenbrier Road in Toledo. Was that mailing returned as being undeliverable?
It was not.
And you suggested that she was personally served by someone?
She was personally served by Davison Investigations. Walter Lovell was the agent who served her. And Your Honor, they may even be available to testify, because I originally asked them to be present today, but then was told we probably wouldn't have time for witnesses. But I do have a copy of their investigation report. And for the record,
I need proof of service, Ms. Moyer. I need proof of service. None in the court file.
Oh, I sent the entire report to Ms. Andres, which has the proof of service attached as the last page of that report.
It needs to be filed with the county clerk. Proof of service needs to be filed with the county clerk, makes in the court file. Sent to the front of the court is not sufficient. So all the court file contains is a proof of mailing of the ex parte order and notice hearing for today's date. to Miss Avery Dugo to an address in Greenbrier Road, Toledo. No indication that the ex parte order was ever served.
I apologize because the report says that the processor filed it with the court. So that was our oversight, and I apologize for that. And we can get that. I'm going to see if I can get somebody over there today. But I don't know if the court would allow it, but I can read directly from the report on how she was.
I need something in writing. I need an affidavit of service for the court file. Reading something on the record is not sufficient. Where was Miss Avery Dugo? Where was she served? In Toledo, Ohio?
She was served at her home at 2 Road in Toledo, Ohio at 7:15 p.m. on April 12, 2022 by Walter Lovell. He was the agent.
Was there some reason why law enforcement did not get involved at that time to deliver possession of the child to Mr. Murphy?
She was being quite aggressive and hostile, both her and the maternal grandmother. They were following the police officers around and verbally assailing them. So Ms. Avery, the report states that she finally did take the papers, and Mr. Lovell informed her that if she failed to adhere to the order, that she could be arrested for parental kidnapping. So she was well aware of the consequences of refusing to turn over the child.
This order, again, signed by Judge Lomar, this court's absence said law enforcement so we can be present if necessary. And I'm trying to understand why Toledo Police Department they were not called at that time.
That is a good question, because it was Patrol Officer Nathan Millam, badge number 2951, Patrol Officer Jeffrey Inslee, badge number 2940, and Scott Park Station, Toledo Police Department. So there were officers there on scene. I mean, my client could testify because he was also present.
I understand. I'm just trying to understand why law enforcement wasn't involved to actually take possession of the child and deliver the child to Mr. Murphy. So we don't know where she's at. You think she's out west somewhere. Who owns the home on Greenbrier? Was it Miss Avery Dugo's mother's home?
My client is shaking his head yes, that it belongs to the maternal grandmother.
All right.
Mr. Murphy, how long had the defendant been residing at the Greenbrier address with her mom prior to this incident?
I don't have an exact date, but I would say around 8 months.
Right. Miss Andrus, does in front of the court, are there any other files open involving Miss Avery Dugo? The name is familiar.
Let me look, Your Honor.
I can actually answer that question.
Cases? She got other children with other fathers?
Yeah, she does.
Yes, okay. And I can give you the case number.
Well, I'm just wondering what address in front of the court has on file for her, those other cases that are open.
Your Honor, the system, whatever it has, for one case, it'll automatically do it for the rest of the cases on our system, but I can double check.
I'm sorry, I couldn't understand you.
What file reflects all the other number addresses?
We have the Greenbrier as well.
Okay, so that appears to be Miss Avery Dugo's address for the front of the court records. Is that correct?
Correct, Your Honor.
All right. All right. Well, the court satisfied that a copy of the notice of hearing, not the ex parte order, but at least the notice of hearing for today's hearing was served upon Miss Avery Dugo, and she has failed to appear. She's not contacted the court. Mr. Murphy, have you tried to text Miss Avery Dugo? Does she respond to any text or communication from you?
I stopped trying once I filed for the ex parte. I was advised not to have any contact.
All right. All right. Right. Ms. Anderson has provided the court fine recommendation. And that the father should be awarded sole legal and physical custody of the 3.5-year-old child of the parties. Mother shall once again turn over possession of the minor child to the father. Both parties are prohibited from removing the minor child from the state of Michigan. Mother shall have supervised parenting time in Michigan by a person mutually agreeable by the parties. And yes, Ms. Anderson, we can, the last sentence is rather than say plaintiff and attorney requesting law enforcement, we can put language in there that we can eliminate that and say law enforcement is authorized to assist in retrieving the child if necessary. So it's real clear.
Yes, Your Honor.
I suppose the court can enter the order, Ms. Anderson, and also your order, Ms. Moyer. Before doing so, let's take a brief testimony of Mr. Murphy to establish this court has jurisdiction over the minor child. At the time this complaint for custody was filed, the minor child resided in Toledo with defendant mother. Is that correct?
No.
Okay, let's take some testimony. Mr. Murphy, can you raise your right hand to be sworn, please? Ms. Moyer, can you voir dire Mr. Murphy, particularly the court wants to make sure that this court has jurisdiction over this minor child, please?
Yes, Your Honor. Mr. Murphy, where was your daughter born?
Wyandotte, Michigan,
And on what date?
9/29 of 20.
And at the time she was born until roughly July 2021, where did she reside?
At my residence in Wyandotte, Michigan.
And did the defendant mother reside with you as well?
Yes.
And sometime in July of 2021, did the defendant mother relocate to another state?
Yes.
And was that in Toledo, Ohio?
Yes.
Did you maintain primary custody of your daughter, meaning that she spent 90% of the overnights with you in Michigan?
That is correct.
And have there been any orders entered prior to the court entering the April 12th ex parte order to return the child to the state of Michigan?
No.
And did you and the defendant mother have a verbal parenting time arrangement?
Yes.
And can you explain briefly what that was?
At what point in time?
So let me just ask it this way. Did you have most of the overnights with the minor child, even though mother had some parenting time?
Yes.
And has your daughter ever resided outside of the state of Michigan in her 3.5 years that she's been on this earth?
No.
Did you at some point move from Wyandotte to Temperance, Michigan?
Yes.
And what date was that approximately?
May of 2022.
And did your daughter move with you at that time?
She did.
And you currently reside there today?
Yes.
And when was the last time that your daughter resided there with you?
April 9th of 2024.
And was that the time that mother abruptly announced she was going to be leaving the state and
Yes.
began withholding your daughter?
Yes.
And does your daughter have her own room in your house?
Yes.
Her toys, clothing, other possessions?
Yes.
And are you the parent who arranges play dates for your daughter, takes her to her doctor's appointments?
Yes.
And has she received her vaccines in the state of Michigan?
Yes. Well, partially in Michigan, the other partial in our doctor in Toledo.
Okay. Have you been the primary caregiving parent for the last 3.5 years?
Yes.
And have there been periods of time when the defendant mother would, for lack of a better word, go missing for days or weeks and you not know where she was?
Yes.
I don't have any other questions, Your Honor.
Ms. Moyer, the court satisfied that Mr. Murphy is an appropriate custodian of this minor child and has been actively involved in this child's life, but the court needs to make sure I have jurisdiction. Mr. Murphy, you filed this complaint for custody on April 12th, 2024. Where did your daughter reside? Did she reside in Michigan, Ohio on that date?
On the 12th, well, I live in Temperance, Michigan.
I understand. You've testified that. Where did your daughter live on April 12th of 2024? Did she live with you in Temperance or did she live with her mom in Ohio or did she go back and forth?
Well, she lived with me in Temperance, Michigan.
Okay. At what point in time did she go to her mother's house?
During the days while I was at work.
Okay. So every night during the months of March and April of February, March, January through April of 2024, your daughter slept at your house and just went to her mom's house during the day. Is that your testimony?
Yes, Your Honor.
Okay. Was your daughter in preschool at all?
Not yet. Coming up this year.
All right. Who claimed your daughter for tax purposes in the past?
I have.
Okay.
Does she also have insurance through the state of Michigan, your daughter?
Yes. Well, but yeah, she was on Medicaid while I was off of work, and now that I am back full time at work, she's on my insurance in Michigan, commercial insurance.
Ms. Murphy, you alleged in your complaint that you were in ICU for a period of time, and that's when when mother stepped in and took the child. Is that correct?
Partially, yes.
Well, okay.
My
when
mother
was
and my
that?
sisters, that was at the beginning of 2023.
Okay, I'm more interested in terms of April of 2024. At what point in time, when did you last see your daughter?
April 9th.
Of 2024.
Yes, sir.
Okay, and your daughter slept in your home the night of April 8th?
Yes.
Okay, and then on the April 9th, mom wanted parenting time, so mom picked her up during the day, took her to Toledo, and then it's the last time you saw her, is that correct?
I dropped her off. Yes, sir.
All right, and during the first 3 or 4 months of April 2024, she was receiving insurance through the state of Michigan, is that correct?
That is correct.
All right, the court satisfied Ms. Moore that Mr. Murphy, that the minor child was in fact residing in the state of Michigan, County of Monroe, with their plaintiff father. Immediately preceding the filing of this complaint for custody, the court accordingly determines it has jurisdiction over the minor child, and accordingly will enter the orders. With respect to your proposed order,
Your Honor, I have one correction to the proposed order, just so it doesn't conflict with Ms. Andres. The way I drafted it initially, paragraph number 7, the parenting time should probably just be crossed out because I asked for it to be suspended, but I think I was a little overzealous with that. And the original motion requested supervised parenting for mom in Michigan, and that's appropriate. So I just wanted to make sure we don't have a conflicting conflict there.
all right, so you're asking court to change words suspended to supervised.
Yes, the way Ms. Andres had it. Supervised in Michigan by a mutually agreeable person.
All right, the court will add that language, initial it. And the court will enter the order that you submitted as well as the one that's prepared by Ms. Andrus. So, and all right, that will conclude this matter. Is there anything further, Mr. Moyer? All I can do is offer Mr. Murphy some good luck in hopefully locating her and having law enforcement to wherever she's at to retrieve her.
Thank you, Your Honor. I appreciate your time.
You're welcome. So, Ms. Andrus, if you can just modify that. The last sentence you can take out and just reword it to say that law enforcement is authorized to assist in retrieving the minor child.
Yes, Your Honor. I have resent that new one to your queue.
All right, thank you.
Thank you, Your Honor.
Court will call the case of Nicole Soltasek versus Stephen Soltastic. I'm sorry if I'm mispronouncing the last name. In any event, this matter is before the court on the plaintiff's petition for her to show cause. This hearing is being conducted via Zoom. President Attorney Zagorski representing the plaintiff mother and moving party Nicole, and she's with Ms. Zagorski. In addition, Anthony Breskel, attorney for defendant Father Stephen, is also present with Mr. Stephen. Good afternoon, everyone.
Good afternoon.
Good afternoon, Your Honor.
Parties have conferred with Ms. Pratt this afternoon. And obviously, Mr. Pratt is frustrated with the parties' inability to co-parent and act like parents. The recommendation is that until such time as the parties can communicate and work together for the best interest of their children, neither party shall be registered or participate in any extracurricular activities. That's the recommendation. Ms. Zagorski?
Good afternoon, Your Honor. I can tell you that my client is heartbroken. I understand the reason that Ms. LaPrada is recommending what she is recommending. I get the logic behind it. My client is, of course, concerned about her children, who at the end of the day are the people who really lose out here. Their daughter, Brianna, has been with this gym since she was 4. This is her 5th consecutive season there. We understood the last order of July 18 of 2023, where it states that the children shall continue to mean that they would continue in their current activity at its current location unless the parties agreed otherwise. Mr. Zoltazik is of the position that he doesn't have to take Brianna. My client would very much like the children to be able to continue to do the things that they love.
She's unable to do that in her parenting time, is that correct?
I'm sorry, Your
Is that
Honor.
the issue?
No, no.
cannot do that in her parenting time?
Mr. Zoltazik is not taking Brianna. Now, he takes SJ to all of his baseball, but he's not taking Brianna to cheer. She just recently missed the clinic for her tryouts for the next season. He's expressed concern, for example, about her teammates being older, so the coach accommodated that and restructured the teams. Everybody's been addressing all of Mr. Zoltazik's needs, but in the meantime, Brianna has not been taken to practice, which I believe to be a violation of this court's order.
Mr. Bresco?
Thank you, Your Honor. Your Honor, our information is only as good as the information our clients give us. So I never fault anybody if there's a mischaracterization of something that happens or it's said. This request, this motion in front of us came about in an ex parte fashion, and it's relevant for the court to know that any of the alleged violations that Ms. Zagorski is citing didn't even come about until after the order was denied in ex parte, and then this was noticed up for a hearing. It certainly isn't the foundation of the motion. And there needs to be a little context, Judge. The minor child, Brianna, recently finished her cheer season at the gym that is in dispute. The season concluded, I believe it was with a grand trip to Florida and a big event. And we are entering a interim voluntary off-season cheer. Because otherwise we would be asked to believe that cheer lasts 12 months a year and there is no break, which of course we know is not the case. And if it is the case, then we definitely need to revisit the order that was implemented back last year when we agreed to continue the extracurricular activities they were involved in, because my client definitely didn't envision a situation where his daughter cheered 12 months a year. But my client has not failed to get this child to her cheer. She attended everything last season, all the way up until the concluding event in Florida. And my client wants this child to cheer. Unfortunately, the two parents and their philosophical views about the gym that they're having the child cheer at have changed. There is a history here where the child has off and on attended this gym since she was a young child. She has also attended other gyms, not as frequent as this one, but there have been other gyms. She also has the opportunity coming this fall to cheer for her school. And she's already signed up for that. And there'll likely be tryouts or something like that, but she's going to have the opportunity to cheer for, I believe it's junior high football. We are not opposed to cheer. We are opposed to this exact gym. And we do not believe that when we entered this agreement just about a year ago, that we signed up for the minor children continuing in the exact team or the baseball team or the exact cheer gym until they're emancipated. That notion cannot be true. We didn't sign up for that. That was not our meeting of the minds, nor did we get enough specifics to have an order that didn't require clarification. So here we are needing this order clarified, because up until then, we were operating under the assumption in my side that anytime we continued an extracurricular activity, it would be for that current session, which we've happily done. We would like to see the young girl cheer for a different gym, one that takes our morals and values into consideration, her health into consideration, and isn't kind of a breeding ground or a grooming platform to just churn out cheerleaders. This isn't the environment my client envisioned her being in this entire time, and that is where the voice of objection comes from. We want her to cheer. That should be said loudly and clearly, and that's why I'm repeating it, just not at this gym, Your Honor. But I have to sadly say, I find myself agreeing with Miss LaPratt, and not because I'm not sad that I'm agreeing with her. I agree with her every day. I'm sad that we had to reach this conclusion as the professionals, because we don't know what else will pressure these parents to co-parent and come up with their own decision that's in the best interest of these children, other than the pressure of these children not being in the activities. And so it's with a heavy heart that I say I agree with the recommendation, even though I don't think it's the right thing to do I don't know what else to do, and I throw my metaphorical arms in the air and say, this is an attempt at trying to make things right.
If I may, Judge.
If the court adopts this recommendation, Mr. Brusco, I mean, Stephen will not be playing baseball.
We understand.
And who's gonna explain that to these children?
Would he be able to continue? For the rest
We would have to ask the
ongoing
court.
season?
I mean,
Because his season wasn't over from the last time this was written.
yeah, my client's indicating, this is all brand new, Judge. My client's indicating that he's in the middle of a season right now. And we have no idea how that would be impacted by this agreement, whether it be right now or it be at the conclusion of the season. But I asked my client.
Neither child shall participate, Mr. Brusco. If the court adopts this, neither party shall be registered or participate, which means he's done with baseball. So I guess dad can inform Stephen, mom can inform Brianna that they're not going to engage in those extracurriculars because their parents cannot agree.
I'd like
now,
to
there's
think
another
that
hearing set for tomorrow. These parties coming back tomorrow to argue about medical bills. Is that correct, or did they resolve that today?
No. We are having a
All right.
hearing in front of the referee on medical bills.
They can come back to court every other day. The court's going to adopt this recommendation. Stephen is done with baseball, and Brianna's done with cheerleading. So, Dad, you inform Stephen, Mom, you can inform Brianna, and until you work together, neither party, child shall participate in any extracurricular activities. Right, that will conclude this. You can zoom out.
It's agreed upon activity.
Thank you, Judge.
That's it.
Thank you, Mr. Brad.
Thank you, Your Honor.